Good afternoon, everyone. We've got a full program for you today, so I want to jump right in just a second. But I did want to make two quick notes. Everyone in the higher education field is probably aware the higher education reopening guidance came out over the weekend. We will be doing a pop-up webinar this Friday at 8:30. Talking about some of the features of that guidance. So please look for an announcement on that if it pertains to you. And also, there has been some PPP guidance that has come out. That's been a weekly feature of these webinars, and we actually are not presenting on it today, but there's some late-breaking developments. So we'll have a pop-up webinar Monday, June 29th at noon. We'll also be getting out an information memo on that, so please look for those. Okay, with that in mind, let's turn it over right now to Erica Wood. She's in our Albany office, and Erica has the unenviable task of trying to describe the benefits and credits that are available under the COVID-19 legislation in a very brief period of time. Take it away, Erica.
Hello, everyone. So I'm going to focus really on the payroll tax credits that are available. And they fall into really two regimes. So we have the payroll tax credits that are available under the Families First Act, which came out, which are available really only to employers who are obligated to pay those additional paid family, medical, and qualified sick wages. So if you have to pay those wages, there are tax credits that are available against those wages. The second regime is what came out under the CARES Act, and that is the employee retention credit. So before we jump into how a payroll tax credit works, very high level payroll taxes generally, each employer has an obligation to remit to the IRS both their share of payroll taxes as well as their employee share of withholding taxes that they take out of the paycheck before they issue that W-2 at the end of the year. So you have Social Security taxes, Medicare taxes, income taxes, and anyone who deals with this knows that there's very significant penalties that go along with not depositing those taxes and not filing those tax returns that are due. So what this payroll tax credit regime does is it gives employers the benefit of freeing up cash flow that they normally would have used and paid over to the IRS that they can instead use to either pay these qualified wages or supplement their cash flow generally. So as I said, there's really the two regimes, but I like to view it as we have three different buckets of potential wages that tax credits can apply against. So if you're an employer with 500 or less employees and are obligated to pay the expanded family leave benefits, then you are going to be eligible to claim a tax credit against those family wages. Same thing, the second bucket would be if you are an employer and you're obligated to pay COVID-related sick wages. So these are due to your employer providing a doctor's note that they're seeking medical diagnosis, or they're perhaps subject to a quarantine. Under that regime, there's actually two different monetary amounts that can apply. And so it's really important, and we're not going to jump into too much of the details there, but it's really important as an employer that you're maintaining the documentation to establish between those two different types. So generally, if you need a third party, like a doctor, to say that you do have COVID, or if you are subject to a quarantine order, the employer is going to need to collect some documentation now to establish the record that they were eligible to claim those higher tax credits on those wages. And then the last bucket, and none of these overlap, is the employer retention credit that's applicable to the qualified wages of employers. And this looks at, did your business either get partially or fully shut down due to a COVID-related shutdown order, or did you see a decline in your gross receipts by more than 50% when you compare against the last quarter? So you see the difference in that third regime is really we're looking at the employer rather than the types of wages that we're paying. We want to make sure that that employer circumstances qualify. And so there may be instances where one employer is actually able to claim the payroll tax credit in each of those 3 buckets. And so I think that's something that people have missed, is that you as the employer may be eligible to claim payroll tax credits against 3 different types of wages. And this can be a very substantial benefit. So I'm not going to jump too much into the various limitations, but what I will say to tie it out in terms of documentation and claiming the credit, so say you're an employer, you've determined that you're eligible to claim any one of those 3 tax credits. How do you go about getting that benefit? Really, what you're going to do is you have the ability, rather than depositing those payroll taxes into an account and paying them over to the IRS, of using that amount as cash flow. So you don't have to deposit it at all, so long as you satisfy the safe harbor requirements. Assuming that you are paying out more and you're eligible for more tax credits than you typically would deposit, in that case, you're going to use the Form 7200 that I know has been talked about on at least one prior COVID webinar. And then lastly, if you don't claim the advanced Form 7200, you're going to reconcile the credit you're due when you file your Form 941. So I know, again, there's been a little bit of confusion in terms of how to claim the credit. You could potentially use all 3 of those mechanisms to claim it. I'm going to have to end there because we'll get too into the weeds, but just keep in mind you might be eligible to claim credits against 3 different types of wages, which is really important. And to the extent you're suffering from some cash flow needs, you might want to consult with your tax attorney or with your accountant about how you can free up that cash flow and get potentially an advance credit if you're eligible.
So Erica, before we let you go here, I'm thinking there are probably, broadly speaking, 2 kinds of people who are listening to this. People who know about the forms you're talking about and are very familiar with it, facile with it, and than others, and perhaps me, who have less familiarity with it. So for the latter group, I think, the lesson would be that, they probably need to be aware of these options and, consulting with the right people in order to make good decisions.
That's right. And I've actually walked through with a few different clients, what their facts and circumstances are and help them kind of guide through. This would be, how you would approach this. These would be the forms that you'll file and when. So, of course, always happy to do that anytime.
Great. We also have some questions here. It looks like we're getting the same question a couple times, so I'll pose it to you. People want to know if they're, taking PPP funds, whether they can claim any of these kinds of tax credits.
Yeah, so the employee retention credit and the payroll protection program, there are some limitations in not overlap. But for the payroll tax credits related to the qualified sick and family leave wages we were talking about, if you have to pay those wages, you would still be eligible to claim the payroll tax credit, even if you got a PPP loan.
Great. Thank you. Okay, let's shift gears a little bit here. Once again, we're going to do a couple things on the reopening, taking a look at, where we are and comparing and contrasting what we've seen. So we're going to start today with Katie Anderson in our Albany office, talking a little bit about phase 4 reopening and what she foresees as we progress. Katie, take it away.
All right. Well, thanks for having me, and happy to be here today to talk with you all about what's happening in New York. Now, just as a baseline, first thing to remember here is the governor last week said he's no longer doing press conferences daily. He'll do them as needed. That has not slowed the pace of things that New York State is putting out. New York State, last night, this executive order went up. And it is an enormous executive order. It deals with the elections, it deals with nursing homes and skilled nursing facilities. It touches on so many different areas that, while we are in a state of reopening, remember that we are still in the middle of a pandemic. So I'll touch on that in a bit. This map is a little dated. I took it from the website this morning, but the mid-Hudson region is now in phase 3. So welcome to all of you. Long Island is projected to begin phase 3 tomorrow. That's big news. That will be, that is indoor dining. We've discussed all of that. The one thing that you want to take a look at is, this week we right now have 5 regions that are projected to enter phase 4. There are some concerns, and this is the map, this is the positive results over time for Central New York. There was an outbreak at an Apple manufacturing facility. They have done, it appears that they've done a pretty decent job of containing it, but the concern here that I have, this is my personal opinion, is that that spike, even if it's small, it can't go above 2%. If it goes above 2%, that will likely delay Central New York in entering phase 4. Same thing with Mohawk Valley. A lot of these same people were in those 2 regions. So just keep those numbers in the back of your mind here, right? Yes, both Mohawk Valley and Central New York are projected to enter phase 4 at the end on Friday this week. But that may change, right? We need to be watching those numbers closely. They are, the governor's office is taking this outbreak very seriously, because it is, it's very concerning. So we want to make sure that's there. Looking, I put this in here as well because it just shows, it's this graph to me is quite extraordinary of what's happened in New York State. Yes, this is from New York City, but when you're looking at how low the percentage is, New York City right now, the infection rate is around 1%. It is quite remarkable. And so, while there is expectations that, the number of infections will increase while phases reopen, we haven't quite seen that yet in the upstate areas that have reopened into phase 3, right? We did see that outbreak at the Apple manufacturing place, but that wasn't a bar, that wasn't, a hair salon, that was a manufacturing place. And it was pretty well contained. So just keep watching this data very closely, is what I have to, say about that, because it will tell you, it will indicate whether or not we're going to get to phase 4 in the next few days, or if it's going to take a little longer. So, looking also at what the governor's been up to, and how this impacts phase 4 and what's coming beyond. This executive order was issued on Friday. So this executive order impacts places that sell alcohol. So anybody that's selling alcohol, a restaurant selling alcohol, a liquor store, a gas station. This executive order came about because last weekend we saw those photos of people in New York City standing on the street, drinking outside bars. They had picked up stuff to go from the bar and they were just standing in the closed street drinking it. No one was really socially distancing. No one was wearing a face covering. Made the governor very mad. And so as a result, this executive order was issued. If you are a licensed premise, you have to inspect, monitor, and otherwise supervise the area within 100 feet of your business. So within 100 feet of your licensed premise, right? So if your licensed premise is now including the sidewalk, it also includes the 100 feet out of that sidewalk area. Why am I bringing this up in a general interest thing about phase 4? Watch this type of enforcement measure. This could become more popular in different areas if places aren't following the guidance that's out there. If, for example, there's a hair salon video that comes up and the stylist isn't wearing the face covering or the face shield, we could see more licenses be threatened to be pulled. And so be aware of that. The governor is taking this very seriously. The governor's people are taking this very seriously. So it's, this is not just going to fade away. And that really bleeds into what is going on with phase 4. Remember that the phases are tied to business reopening, right? They are not tied at all to the restrictions that are in place on people individually, but also, the restrictions that were put in place by a prior phase. So a manufacturing facility has to continue to follow the phase 1 guidance throughout all of this. And even once a region hits phase 4, every business still needs to be following that applicable guidance until we hear otherwise from the governor's office, or until that guidance is changed. I expect that guidance may be tailored and will be shifted and changed as this virus and what it's doing in New York shifts and changes as well. But keep following those plans. You're going to keep needing to do them. And remember that the 4 cornerstones that we keep talking about, that applies, that will continue to apply. If all things are uncertain, know that these 4 things are certain. You're going to have to wear face coverings out in public. And while you're working, you're going to have to continue to practice social distancing. You will have to continue screening your employees, and you will have to continue sanitizing and disinfecting your facilities and your business throughout all of this. That's, we don't know when things are going to be lifted. The governor's office is talking about a phase 4 plus. Phase 4 is a new beginning. And I expect there will be more updates to give once we are in phase 4 in more regions. We will know more once we're there, which is not very helpful for planning purposes, but for planning purposes, know that the guidance that exists now is going to continue to apply, and you have to continue to use those 4 cornerstones. And I yield my time to the chair.
So Katie, before you go, just real quick, I have this image. I remember the governor, using the image of, turning the pipeline on, seeing how it goes, maybe adjusting it a little bit. And something you said earlier in your presentation sort of brings that in mind, that this is not an automatic progression every 2 weeks, that it is an evaluative process. And so depending on how the numbers go, we may see some turning of that valve, possibly even turning it backwards in theory. Is that a fair statement?
That is. And what's been, I know that there's been lots of discussions about the impact of protests on COVID spread, right? But we have yet to see it. Anybody who has been at one of these protests can go and be tested. But it appears that the majority of people are wearing face coverings, and that seems to be effectively stopping this spread. If that's wrong, right? If in 2 weeks I am fully incorrect about that, and we see cases start ticking up, perhaps as a result of the protests, perhaps as a result of just people doing more and more, right? We're going to see a walking back of some of these measures. Likely.
Okay, thank you. So those 4 cornerstones, very helpful for everybody. Okay, let's go to Adam. Adam Masterleo is a member in our Syracuse office. Adam's been with us a number of times here on reopening. One of the thoughts we had was, and I mentioned previously, we're going to have a higher education dedicated pop-up webinar this Friday at 8:30, but some of the compare and contrast items with the new guidance and the prior guidance gives us an opportunity to sort of see where we are and also what that might mean. So Adam, take it away.
Hey, thank you, and it's good to be back. I know last week we talked a little bit about reopening fundamentals, and the process was to perform your risk assessment, read and understand the state's guidance applicable to your industry, develop your workplace safety plan, implement and communicate your plan, and affirm that you are going to comply with the state's guidance. Over the weekend, the state released its higher education guidance, and this is something that I know higher education institutions across the state were waiting for some time. This is particularly important because higher education institutions involve so many different little areas or specific areas that the state hasn't addressed yet. And so all colleges who want to bring their students back were very excited to see what the state was going to say. Now, what I want to do right now is go through what we see that's the same in the higher education guidance and what we see that's new and different. So first of all, what is the same? And I think that if you look at the guidance that the state provided, there are summary guidelines and there are also detailed guidelines. The summary guidelines go through the same general categories that the other guidance has provided. So Katie touched on the cornerstones just a moment ago. Those cornerstones are contained within the higher education guidance. So there are requirements relating to physical distancing. There are requirements related to PPE or face coverings. There are requirements for hygiene and cleaning and disinfection. There are requirements for communication, and there are requirements for screening. So those things are going to be the same, generally speaking. There are many differences, however, so I do want to spend some time highlighting some of those differences. With respect to face coverings, as many of you are aware, employers in all the other industries are required to provide face coverings to their employees at no cost. The higher education guidance continues this requirement, but only for employees. The guidance says that higher education institutions have to provide face masks at no cost for their employees, but it doesn't contain the same requirement for students. In addition, with respect to screening, the requirements are very different. The screening section in the higher education guidance talks about screening for symptoms, just like all other employers are required to do. However, employers in other industries are required to screen on a daily basis. According to the higher ed guidance, higher education institutions have to screen their employees on a daily basis, but they don't necessarily have to screen their students on a daily basis, even those students who are residing on campus. So the guidance provides some information about or some general recommendations about what higher education institutions can do, but it doesn't require screening on a daily basis. Another important distinction regarding screening is that the higher education guidance recommends and provides as a best practice actual testing for COVID-19. And it talks about testing both as an introductory step when students and faculty return to campus, but then also potentially screening and testing on a more regular continual basis. Mind you, this is not a requirement in the guidelines, but it is discussed as a best practice. In addition to the general categories that we've seen throughout the industry guidance, the higher education guidance also provides what they're calling a reopening plan checklist. This is not something that was included with the other industry guidance. And this checklist walks through the categories of information that need to be included in the plan. This is very different than what we've seen in the other industries. For the other industries, we've seen the template. So the state developed this workplace safety template, and it attached it or provided it with its guidance for all of the other industries we've seen so far. Phase 1, Phase 2, and Phase 3. So the state, I think, in failing to provide a template is acknowledging the uniqueness of each higher education institution, the different requirements that each institution is going to have to come up with, and that there really is no one-size-fits-all solution for higher education institutions. So within the additional checklist that the state provided, we see the following things. We see that plans have to determine or discuss capacity. How many students are going to be allowed on campus? How are higher education institutions going to deal with remote students? This is very different. For other businesses, for example, for offices, we saw a 50% limitation on maximum occupancy. Similar limitations in other industries. There was no such limitation in the higher education context other than to require institutions to talk about how they're going to deal with capacity. The checklist also includes requirements regarding residential living situations, how you're going to house students, how you're going to maintain social distance within residence halls. It talks about operational activities, how classes will be performed, what students will be allowed in classrooms, how teaching will be performed, etc. So the checklist has these very general reopening categories. The checklist also requires higher education institutions to cover monitoring, how they're going to monitor who has the virus, and this is where it discusses testing. Containment, what is a higher education institution going to do with students who live on campus, with students who live off campus, with employees? How are you going to respond to those different populations when they test positive? Are you going to isolate? Are you going to quarantine? Where are you going to do that? So the plans are going to be required to address those issues. In addition, the checklist mentions shutdown, that higher education institutions are going to have to address in these plans how they're going to or what they're going to do about potentially shutting down classes, classrooms, buildings, etc. So all of those things have to be addressed as part of the checklist. Now, the most significant difference, I think, is that for the first time, we're seeing an industry where the plans have to be submitted to the Department of Health. The guidance requires that each higher education institution adopt a plan, just as it does for all other industries. But then it requires the higher education institution to upload the plan through a link that is provided in the guidance to the Department of Health. The guidance doesn't talk about requiring approval of the plan. It just states that the Department of Health may make changes to the plan if it thinks it is appropriate. So that's a real big difference. Higher education institutions have to submit their plans. So that's something new. One other final note, Pete, that the guidance makes clear is that higher education institutions, as we know, contain lots of different mini industries within them. So for example, a lot of colleges have a bookstore or retail store. Colleges provide food service. Some colleges provide transportation for students. What the guidance makes clear is that for each of those industries, where they would otherwise have separate guidance applicable to them, the higher education institution has to adopt a plan that meets those requirements. So for its office employees, the higher education institution has to have a plan that complies with the phase 2 guidance for office industries. Similarly, for transportation, they have to comply with the public transportation guidance, etc. So that's another big difference. As Pete said, we're going to be talking about this in much more detail on Friday morning. So if this is an area that is of particular interest to you, please, we look forward to seeing you on Friday.
Thanks, Adam. Let's turn now to Gail Norris. Gail's in our Rochester office, and there has been a lot of conversation about waivers and waiver considerations. And, Gail's got some thoughts in terms of, your waiver analysis and things you might think about if you're contemplating waivers or not contemplating waivers. Gail, take it away.
Okay, thanks, Pete. Good afternoon, everyone. Yeah, with like all infectious diseases, even the best laid workplace safety plans that have been the topic of discussions on these webinars are not going to eliminate the risk of infection of the disease, and potentially that could be occurring on business premises. So businesses are understandably concerned about someone who could claim in a lawsuit that the company is liable to them for the fact that they contracted COVID-19 on their premises. And we've been getting a bunch of calls about what we do about that. So we thought that we would review just quickly the two big legal concepts that are possibly available to provide some protection to businesses from, such a claim by someone who visits your premise or works there. One is the liability waivers, and I'll deal with that secondly. The first one is the concept of assumption of risk. That is a legal defense to a negligence action that prohibits a plaintiff from recovering damages because the plaintiff knew of a risk and willingly assumed it. I think most people have been exposed to at least the concept of assumption of risk. The classic examples are, an athlete playing a contact sport that breaks an ankle or an arm playing the sport, or a vet who gets bitten by a dog in the course of treating it, that are just sort of known to be inherent risks in what you're doing, and you've assumed that risk. The defense can be used without having to have a prospective plaintiff sign anything if the risk is inherent enough to be so obvious, as in sort of the classic cases I just gave. But businesses can also have people sign and express assumption of risk. And in this case, it would be that, that the person is aware that despite the safety plan, compliance with it rely on the participation of every individual to adhere to the hand hygiene and masking requirements of the plan, and as a result, the risk of infection can't be eliminated, and the person on the premises acknowledges that. Even if it's not in an express assumption of risk document, I think businesses are well advised to at least consider putting some language in your signage or your other communications that let people know that you've got the safety plans in place. I don't think there's going to be any exposure limitation for not having a good safety plan, but despite it, that the individual compliance by the people on the premises is impossible to monitor on a regular basis, and so that risk of infection remains. The assumption of risk defense, like the waiver of liability that I'm about to talk about, has not been well tested in courts on infectious disease. There have been a couple cases that have actually upheld the assumption of risk defense, but not at all tested in the COVID environment. So we don't know exactly what that would look like and how successful it will be, but it's potentially available. The second legal concept is this liability waiver, and that's a written agreement waiving any liability of the business. In this case, it would be for COVID infection. They are enforceable in courts across the country and in New York, but there are a lot of caveats. The first one is there's no waiver allowed for gross negligence. The standard between negligence and gross negligence is a little bit hard to articulate in the short time I have, but an extreme example would be as if there was somebody that had symptoms of COVID that the employer knew had those symptoms and didn't take action to remove the person from the workplace, and they were there for an extended period of time. I think that's fair to state that would be a gross negligence standard, and no waiver is going to protect you from that kind of exposure. The other thing required for a liability waiver is that the language must clearly and specifically state that the signer is waiving the negligence of the business, or similar language to indicate that the waiver is of specifically the neglect or the fault of the person seeking the waiver. Well, that language looks sort of ugly depending on your what customers or clients you may be giving it to, but it needs to be that express. Can't be in small print. It's got to be right there in people's faces when they're signing liability waivers, so that they know exactly what they're signing away. Courts do not like to enforce liability waivers. They do, and they have, but they look for ways not to enforce them. And there were a lot of public policy cases over the years where courts refused to enforce waivers for public policy reasons, and they ended up, many of them being codified, at least in New York, in the general obligations law. So there are certain industries where liability waivers are not possible. Landlords are one example. Contractors are another. Certain recreational facilities that charge fees for access to the facility are another, all reflected in the general obligations law. So there are some industries it's not even possible. If you get it, it won't be enforceable. For employees as well, liability waivers are not recommended for several reasons. First, there's workers' compensation, which is supposed to be the employee's sole remedy for workplace illness. And the workers' comp law specifically says employees can't waive their workers' comp rights. Even if an employee can argue around whether or not COVID is a workers' comp illness, one of the public policy reasons that courts have historically rejected liability waivers, and specifically also in the employment context, is the unequal bargaining power. You give the employee a liability waiver to sign, the courts presume that the unequal bargaining power makes the contract, contract of adhesion, or basically forces the employee to sign it and won't enforce it. And then there are OSHA standards for workplace safety that are not waivable. So getting liability waivers for employees is likely not going to be enforceable and probably not a good idea. For others who visit your premise, again, the liability waiver is possible to get. It's untested in court. It's unlikely to absolve a business of having a reasonable safety plan that they themselves follow. And then beyond that, it's going to be a facts and circumstances test. Businesses are going to have to weigh the feasibility of obtaining waivers for visitors, and in the case of, for instance, a retail establishment or a dining facility, it might be hard to run around collecting liability waivers from everybody who visits your premises. Well, so that feasibility needs to be considered, and then the optics of the language that has to be in there, where you're telling your customer or client that they're waiving your negligence in the operation of your business, as that language is required from the waiver, is going to have a reputational issue or an optics issue that you're going to need to consider, and you weigh that against the protection it might give you. The last thing I'll note before I turn it back to Pete is that companies should probably give a call to their insurance broker or agent to just check it. If there is a suit for COVID, it's likely to be a negligence suit, and you have liability insurance that should cover negligence actions. So getting your broker's thoughts and sort of poke around at your insurance policy and whether there are any recommendations coming from your insurer, whether there are any coverage issues you should consider with respect to this risk, would be a good idea. And Pete, I'll turn that back to you.
Thanks, Gail. A couple things I heard you say that make just a lot of sense as baseline advice. One is that the notion of following your plan, right? That, the plan that's in place has been, sort of specified, at least in large detail, by the state. And everyone should have a plan, and they're most likely having to affirm that they have a plan, and then, so following it is going to help. But the other thing that I just want to get your comments on is short of a waiver or assumption of risk, which tends to be formalistic, legalistic, and has some of the issues that you've highlighted here. It may be possible to just communicate to people who don't know what your plan is, and so rather than asking them to waive everything, just notifying them, we expect that you'll engage in social distancing, wear a mask, etc. Well, what do you think about that as a potential option?
Yeah, I think both. Certainly, I think part of a good safety plan would be communicating with anybody that's on your premises about what those safety requirements are, so they can follow them. But I also think it's worth it to consider going one step forward and saying, the effectiveness of this plan depends on everyone following them. And we are going to, make good faith efforts to enforce it, make sure everyone knows them. But there is some risk there if people don't follow the plan, that there can be some infection.
Thanks. Okay. Let's turn now to Kate McClung. Kate's also in our Rochester office. We've talked about this periodically, but I almost feel like we can't talk about it enough because it's a complicated issue and it's one that I know everyone's facing. So accommodation issues, and especially as we continue to reopen, we're going to see these surface. And so Kate's got some thoughts.
Thanks, Pete. So certainly as more and more employers are reopening and more employees are coming back to work, many of you are probably getting more requests for accommodations, including ones that are fairly specific to COVID that are unlike any accommodation requests that you've received before. So I think the number one question I get on accommodations is, I have an employee who's just too scared to come back to work. And what do I do about that? Certainly being scared, general fear, while understandable, isn't by itself a protected disability. But there is a fine line here too, because is the employee just scared to come back due to COVID-19, or has COVID-19 exacerbated a pre-existing mental illness or mental disorder such as anxiety disorder, OCD, PTSD? Because if that's what's really going on, then an accommodation would be necessary. So it's important to recognize that distinction when you're dealing with someone who comes to you and says that they're scared. You may want to ask some follow-up questions to try to flesh out, is this just someone who's scared, as many people are, or is this actually connected to a protected disability? Other issues we get involve pregnant and older employees, and there's kind of two sides to these employees. So the first is involuntary accommodations. Employers, in a well-intentioned move, want to protect employees who are at risk, including pregnant and older employees, and ask, can I require these categories of people to work from home? I know they're at higher risk for COVID-19. Can I do this to protect them? And the answer is no. If you're treating them differently because they're pregnant, because of their age, you're at risk of a discrimination claim. The other side of the coin with these employees is where they come to you and ask for an accommodation. What are your obligations there? So with pregnant employees, pregnancy itself isn't a disability, but pregnancy-related conditions can be disabilities under both state and federal law, requiring accommodations. Additionally, under the Pregnancy Discrimination Act, if a pregnant employee is unable to work, they're entitled to the same treatment as another employee who has a similar limitation on their ability to work. So if you're permitting employees who are immunocompromised and therefore at risk of COVID-19 to telework remotely, and a pregnant employee in a similar role at the company asked to telework remotely, you would want to be consistent of your treatment between those two groups. With older employees, the Age Discrimination Act doesn't have an accommodation requirement like the Disability Discrimination Act. So if someone's asking for an accommodation purely based on their age, that's not legally required. Certainly you can go beyond what the law requires and grant accommodations to older employees if you choose to do that. Now, if someone comes to you and says, I want to work from home because I'm 65 or whatever the case may be, even though that's not legally required, you may want to ask some follow-up questions, because maybe they do have a protected disability and maybe they're entitled to an accommodation on that basis. Another question that we've been seeing clients get is from employees who have high-risk family members. And so they don't want to come into work, or they want certain protections in the workplace because they don't want to contract COVID-19 and bring it home to their high-risk family members. Now, that is a category of people who are not protected by the disability accommodation requirements because the employee themselves doesn't have a disability. Another issue is accommodations at home. Usually pre-COVID-19, we always thought of accommodations as being in the workplace or enabling someone to get to or from the workplace. But with more and more employees working from home, it's important to keep in mind that you may be getting accommodation requests to enable someone to work from home. And that is something that's still covered by the law. Documentation, you still have the same right to documentation as you've always had. You don't need to require documentation to provide an accommodation if you grant the accommodation. But if you're thinking about whether or not to grant or deny the accommodation, or considering alternative accommodations, certainly documentation is something that can be very helpful to you in that process. I've gotten some questions about the interactive process and how to do that when some employees are working remotely and some are in the office. And I think we've all gotten a lot more adept with using video conference technology and getting used to handling things by phone calls that we might have used to have done by in-person meetings. But it's important to remember you can't postpone the interactive process just because it's a little bit more inconvenient because they're not in the same location. As part of the interactive process, you can provide a temporary accommodation. Even the outcome of the interactive process can be, we're going to grant you this accommodation, but we're going to grant it to you until, say, August 10th. Now you've said you're going to have this limitation for the rest of the year. We're going to grant the accommodation to August 10th, and we're going to revisit then, you know, recognizing that the situation's changing still pretty rapidly with COVID-19. And so the world might look very different in August than it looks now. And so you might want to set that deadline to revisit at that time and to kind of check back in. Another thing is undue hardship. So the EEOC guidance talks about how in some ways it may be easier to prove undue hardship with COVID-19 because while historically the EEOC has been very unforgiving when an employer has argued, well, this accommodation is just too expensive, in their guidance on COVID, they indicated that where the employer's income stream has really dried up or they have very little available for discretionary funds, you may have an easier time proving undue hardship. Now, it is still a high standard. That doesn't mean you can just reject any accommodation because it costs something. And I definitely recommend you consult with your counsel before relying on the undue hardship. But it does sound like the EEOC is going to be a little bit more flexible when it comes to financing. Another thing that they mentioned with undue hardship is where it's more difficult to get something. So for example, if an employee doesn't want to wear the cloth face covering you've provided and has asked you for an N95 mask or some other specific piece of equipment and you can't get it, you can't find a place to buy it, that could be something that you could rely on to show undue hardship, at least while it's still unavailable. One other note on undue hardship is, you know, while the EEOC guidance talks about ways that it might be easier to prove undue hardship, one way where it might be harder is if you have an employee asking to telework as a reasonable accommodation. Normally, you know, if you have a position where no one's ever teleworked in that position and you feel very strongly it needs to be done in person, you might try to argue for undue hardship. But if this employee has been working from home for the last 3 months and has been getting all their work done successfully, it's going to be a lot harder for you to say, well, it's an undue hardship to have them working from home because they've proved that they can do it over the last few months. So that's something to keep in mind as well. So those are my highlights on accommodation for today. Turning it back over to you, Pete.
Thanks, Kate. That's a great summary and I think a useful progression for people to see, you know, the various questions and how we work through it. You know, one of the interesting things I think, and we've had this question a few times, is some people, as you say, have been working from home successfully. In other situations, essential functions of the job may have been temporarily eliminated due to the COVID crisis. And so the real question, the difficult question is going to be, have people been able to perform all of the essential functions of their job at home effectively, or have they just been doing, say, 80% or 70% of their job because that was all they could do? And so eliminating essential function is not a reasonable accommodation, but if someone can perform the essential functions with reasonable accommodation, then of course you must let them. And so that middle ground, I think, is going to be a little bit tricky as people try and navigate it.
Yep, that's an excellent point, Pete.
Okay, so I think we're pretty much out of time. Thanks everyone for participating today and hanging in with us. We'll talk to you next week. Stay safe.